No. Well, no, I just did this. What is this then?
Good afternoon. My name is Jim Cheney, and I've been designated by the City of Salem as hearings official for today's hearing. For the record, it's 5:30 p.m. on June 11th, 2025. We're met in the community room at the Salem Police Department located at 333 Division Street Northeast in Salem, Oregon. This is the time and place that's set forth in the notice for the hearing on variance case number TRV 25-02. This is an appeal of a tree regulation variance to remove 23 trees and vegetation within a riparian corridor, including 4 significant trees to install a sanitary sewer line. Salem Revised Code, Chapter 300 sets forth the procedures applicable to land use applications. Under Section 300.2, appeals of tree variance applications are heard by a hearings officer, which is why I'm here today. Under SRC Section 300.1010, a decision on land use action may be appealed by a person or entity withstanding to appeal by filing a notice of appeal with the planning administrator within 15 days of the date of notice, which has happened in this case. And SRC Section 300.1040 sets forth the procedures for appeals. I want to make clear that under the code, appeals are de novo, which means that all the issues of law and fact that are relating to the application are heard anew. And no part of the city's decision is binding upon me as hearings officer. Any party may present new evidence in legal argument. The record will contain not only the evidence and the arguments that are presented at this hearing, but all the material in the staff reports and the written testimony received to date. If necessary, the hearing may be continued to a later date, in which case notice will be given in the same manner as was given for this hearing. Following the close of the hearing, I, as hearings official, will consider the testimony in the record, and I may affirm the decision, the city's decision, affirm the decision with additional conditions or modifications, reverse it, or remand the decision back to city staff for further action. I'll note that the appellant may withdraw its appeal at any time before I render that decision. If the appeal is not withdrawn, I'll issue a written decision in writing, which will include a statement of the facts relied upon in making the decision, conclusions of how the standards or criteria have been met or have not been satisfied by the facts, and an order that either affirms, modifies, remands, or reverses the city's decision. That decision will be distributed by the city as provided in Salem Revised Code. So we'll now proceed with the hearing. I will first call upon the city staff to present their analysis. Following the city, I will then call upon the applicant and the appellant to present their respective cases. There are time limits associated with these. The applicant is to limit its presentation to 15 minutes, the appellant to 10 minutes, and any others who are here to testify to 5 minutes. So at this point, I call upon city staff, Manager Olivia Diaz.
Oh, wait, share. The glare is so bad. Okay.
Good evening. My name is Olivia Diaz. I'm the current planning manager, and we're here for tree variance 2502, located at 2085 Wellington Avenue Northwest. I would like to enter the staff report, this presentation into the record. I haven't received any other comments, so those two things. The request is for a tree variance to remove 23 trees from a riparian corridor. Of those 23 trees, there are 4 significant trees, and so there was an additional variances to address those under separate criteria. There was an additional significant tree listed as dead. So because the tree wasn't living, it was considered a riparian vegetation, which is part of the 23 variances above. A little bit of background on this property. To the west of this property, there was a previous subdivision approved, affirmed by council, and affirmed by the Land Use Board of Appeals. That subdivision required a condition of approval for connecting sanitary sewer through this subject property to an existing sewer line that butts the subject property. There has been multiple rounds of public construction permits. Those are entered into the record. And have been available online, and there has been a draft wetland delineation entered into the record. The subject property, as shown in red, is the Calpullia Elementary School. It's north of the middle school. Like I said, Wilnark Brook goes through the subject property and is surrounded by residential. This is a little bit closer view of the vicinity map. The area of the tree removal is shown in green near Wilnark Brook on the back side of the school. So it's located more than 300 feet away from any school facilities. The subject property is residential agriculture, which contains the school. It's surrounded by residential agriculture and single family residential. The testimony that was provided in the appeal was based on the fact that it was incomplete or inaccurate submission. The approval findings did not accurately address the comprehensive plan, specifically goal N1, and that submittal requirements required a complete delineation, wetland delineation, that was not submitted. Testimony that was submitted, there was 3 comments submitted prior to the planning administrator decision, and those were addressed in the planning administrator's decision. Comments were received from West Salem Neighborhood Association. They were addressed in our original decision and in the hearings officer staff report. To talk a little bit about the sewer line. So if you can see, the subdivision is on the left side of your screen. The area where the tree removal is highlighted in green, and the orange with little arrows is the sewer line. So this is the entire utility plan for the city of Salem for the sanitary sewer. There's no sanitary sewer anywhere in this area besides that connection going to the north. This is the applicant's site plan showing the trees being mitigated. You can see there is the hawthorn tree on the top right-hand corner that was identified as dead. The 4 significant trees are highlighted in red. As part of the findings presented in the staff report, we used the no other reasonable design alternatives that are generally found in our tree removal permit decision criteria as a justification for our hardship. There is a hardship because this is the only location for sanitary sewer, and we use the similar criteria that's available within our tree removal permit for the justification for that. So the tree variance criteria is special circumstances that apply to the property that create an unreasonable hardship, minimum necessary to otherwise allow the lawful proposed development, and then the mitigation in the riparian area. So we, like I said, address the hardship, unreasonable hardship and practical difficulty due to the fact that the sanitary sewer is only in the one location. The applicant has proposed the minimum necessary to be able to bore, to dig out and install the line. That's been reviewed by our natural resources staff. It's been reviewed by our stormwater staff, and both of those divisions have provided mitigation for the riparian area. They have requested that all of the materials be removed from this area due to flood restraints and replanted as mitigation to better the riparian area. So these were the conditions of approval recommended by our staff, so natural resources staff, which were imposed upon the planning administrator's decision. Staff recommends that you approve the tree variance with the conditions of approval outlined in the planning administrator decision. I'm available for any questions if you have questions.
I don't have any additional questions at this time.
Okay, I'm going to leave this map up because I think the applicant would like to use it.
Good evening. My name is Natalie Janney. I'm a civil engineer with Multitech Engineering. Our office is located at 1155 13th Street Southeast. There are times when variances are a little bit more challenging to justify, things that are a little bit more subjective or that have a little bit more flexibility, like where a road goes, or even water lines have a little bit more give because they're pressurized. But when it comes to sewer works by gravity. And so we're dictated by topography and what flows downhill. The existing sewer that Olivia pointed out to the north, I don't know, this sewer location right here, that is the sewer that is stubbed for both of these properties. It was put in when this subdivision was developed in the late 80s with the intention of providing sewer service to this property. And it was actually meant to follow all the way along Willark Brook up to Orchard Heights. And so this development tying into this sewer, which is actually condition 14 of the subdivision approval for this residential development, falls in line with the history of development in this area. And so part of it is this idea of, is there a reasonable alternative? There is not, because of the topography and the need for a gravity-fed sewer in order to develop this property. We have to have sewer in order to have homes. And so to not allow a sewer connection would mean that this property would not be able to develop into needed housing. And furthermore, under ORS 197, needed housing has to have clear and objective criteria without undue cost or without unreasonable cost or delay. And we would say that any other alternative except for the connection to this existing sewer stub would go against needed housing statutes. So I want to keep it, keep it simple and sweet. That's really why the connection here is proposed. We really appreciate Olivia's staff report and the presentation she did, because we feel like it outlined all the issues and the history of the project, as well as the submittal, the things that are required by submittal. We did submit some extra responses this evening. I'm sure you have not had a chance to read them.
I don't have them.
Oh, you're submitting them into the record.
There we go.
I've got one.
I have oh, there we go.
There you go.
Thank you.
So that is, that's where I'll leave it until if we hear anything else from the appellate. I will be back for rebuttal. Brandy, is there anything else I left off? Work has been done to minimize the impact, and we agree with the conditions for replanting and mitigation.
Yeah, and as I understand that, then the Public Works, you're running the line, constructing manhole there. And that you're replanting with shrubbery that's within the area of the easement. And then the trees that are replanted are outside the area of that. And I presume that's for potential access to the line later.
Yeah, right.
The appellant.
That's the presentation for the appellant.
From the applicant, the appellant. 10 minutes.
Your Honor, I'll take approximately 3 minutes and then the balance of the appellant's time will go to Mr. Easterly and he has materials to hand in. My name is Steve Anderson, West Salem Neighborhood Association Land Use Chair. So, Your Honor, we request a reversal of the May 1st, 2025 decision and a denial of TRV 25-02. At a minimum, a remand of the May 1st, 25 decision approving TRV 25-02 to the planning administrator for further action. It is our contention that the TRV 25-02 application was and is incomplete. We will enter documentation evidence tonight of 10 errors with supporting references and appendices tonight showing that. 1, there is sufficient evidence and examples where compliance with the Salem Revised Code has not been met in this case. 2, findings claimed are without evidence in the record, omissions for decisions made thereupon. And 3, outright errors in facts claimed in this matter. For example, the issue statement published for this case makes at least 2 incorrect statements. 1, this is reported as a tree variance case. The record, however, shows a tree removal permit and a significant tree variance filing. There is no second variance request or acknowledgement in the record. 2, the reported 0.84 acres for the property has not been verified. This is a land use decision and making process. More troubling is that the record has been altered with additional documents placed therein after the May 1st, 2025 decision was final and published. These additions include 1, draft wetlands delineation submitted to DSL entered into the record approximately 5/30/2025. 2, sometime after the 1st of June, a restoration and mitigation email dated 4/25/25. The record here is tainted. Given the final May 1st, 25 approval of the decision and this May 1st date cited and noticed as the objective of this hearing, all filings and alterations of the record thereafter were outside public review and comment prior to the original decision. No notice since the record alteration was provided the appellants, nor the public or adjacent property owners. We have a land use goal 1 issue here and non-compliance situation. The Ghost Goal 1 violation alone is sufficient reason to immediately remand and open this case or outright denial of it. We believe that altering the record and this Goal 1 violation demands a summary judgment offering grounds for denial of this case or immediate return to the planning administrator for opening this case for further actions. So requested. Mr. Easter has the rest of our testimony unless you have questions.
Thank you.
Okay.
Good evening, Your Honor. I am E.M. Easterly. I live in Ward 8, West Salem. Mr. Anderson has pointed out to you that we are presenting 10 specific errors involved with this decision. I'm going to summarize those in general right now before passing on to you the written document. Insofar as TRV 25-02 is a land use application rather than a post-tentative subdivision engineering approval process, we ask that the May 1st, 2025 TRV 25-2 approval be canceled, that the weakly justified conversion of a tree and vegetation removal permit into a second tree regulation variance focused upon the riparian corridor along Willard Brook be rejected for the following reasons. The adopted findings fail to define the physical site of the submitted application. The adopted findings fail to explain the legal restrictions that cause either undue hardship or economic taking upon the owners of the Willard Creek subdivision. The adopted findings do not contain a second variance application or the requisite application information. The adopted findings do not include an official cancellation of the original tree and vegetation removal permit. There is no evidence in the record that the applicant paid the additional fees associated with a second variance. There is no wetland determination evidence north of the 24J property line and the site of the actual Salem Sanitary System stub. There is neither a riparian corridor nor a wetland restoration requirement in the adopted approved TRV 25-02. Let me repeat. The record is incomplete and requires correction. The missing items include: 1, a complete application form, which includes all A2G listed items for a riparian corridor tree regulation variance. 2, the date stamped application for the riparian corridor tree regulation variance application submitted by the applicant. 3, payment of the applicable application fees for the riparian corridor tree regulation variance pursuant, and I push the word pursuant, to SRC 110.090. 4, the total site area, dimensions and orientation relative to north impacted by by TRV 24-02. And 5, the type and location of native vegetation within the riparian corridor proposed to be removed. That is a requirement very specific to 808.045 C2B. Based on this information, please return TRV 25-02 to the Salem Planning Department for revisions and legal corrections so that the final approval conforms to the land use requirements of the Salem Revised Code. Thank you for your time. With your permission, I'd like to hand you a document. Okay, thank you. Both of them go together.
I'll scan these.
Oh, yes. No, please, wait there, you can have your copy. That's his. Here's yours. Yes.
Here, these two copies are the same. Do you have a copy of these?
I do.
So you can scan them.
I'll scan them and put them in the record.
So we'll take those will go into the record along with the applicants. In your PowerPoint presentation.
And my copy. If you would like, I could address some of the record things that were brought up if you want, but.
Go right ahead, yes.
As the hearing was de novo, sir, we did add items to the record after the planning administrator's decision that detailed staff work that we used to write the original decision. Though it's internal work that we used, like permits and such, that were not put into this application. Those were added after the decision was issued, but since this is a de novo hearing, all of that has been added into the record prior to as part of this hearing process. The application question about it being a tree removal permit versus a tree variance, I will tell you that everybody submits for a tree removal permit in our online system. It's just the first one that comes up. And as we process with an applicant, the application that was submitted does say planning action involved tree variance is listed on that application and signed by the applicant. The fees have been paid. The fees are paid based on, there was a riparian variance fee that was charged, and then there's a significant tree variance per significant tree. So there's two different fees. Those are both been paid and are in the file. I think that was, so there was no need to cancel a tree removal permit because there was no such tree removal permit. This doesn't qualify for a tree removal permit. This is a higher classification application than a tree removal permit. If it was a tree removal permit, it would have been administrative and not sent out to notice. And we, as the staff, placed conditions to meet the approval criteria for the restoration plan. So I don't know if the restoration plan was needed as the conditions of approval meet that criterion for needed housing. That's all I have. I'm not going to speak to any of the criteria, but the administrative part of it.
I think that the original appeal said that there hadn't been a wetlands delineation. That's one of the things that was added after the application.
Yeah, it was part of the public construction plans that were reviewed. So we've been reviewing public construction plans for probably 6 months. And so that was just part of the feedback that the applicant has been given to where they need to locate the trees. We've been talking about they need a tree variance for 6 months. So that was all part of that permit package and what triggered this, right? And so that just wasn't put into this file until after.
Your Honor, may we respond real quick?
There'd be an opportunity to do that if we leave the record open. Are there any other persons who are here who wish to testify in favor of or in opposition to the application?
And Mark, you're first on if you want to. And then Brian.
Do you want to go?
No. See, Ryan Rodell and Mark Farrell.
They both aren't testifying.
Okay.
That's everyone here.
Okay, if there's no one else here to give testimony, then I've accepted into the record the PowerPoint presentation that Ms. Diaz presented, as well as the submittals from the applicant of the appellant. So with that, I'll go ahead and close the hearing. Oh,
The applicant gets to rebut.
oh, that's right, sorry.
I don't have too much to add. I think Olivia did a good job talking about the submittals. The history with the Willard Creek project and the West Salem Neighborhood Association has been, the West Salem Neighborhood Association has been really exercising NIMBYism in terms of preventing this development. So I'm trying really hard to figure out how to respond without addressing that aspect of it. In terms of this application, as Olivia pointed out, we have met the criteria. We've met the submittal criteria. I know we've paid the fee because we've had plans held up by the city of Salem for like $40 before. So I know that the city would not let us do anything without paying the fee as they should. And so we've submitted a wetland delineation plan. We've complied with everything. We're willing to do the restoration. It is necessary in order to provide needed housing for the approved subdivision. Yeah, happy to answer any questions. I think that pretty covers it. This is pretty cut and dry. I mean, you have to have sewer. So thank you.
So I'll get it close.
You're okay.
Okay, in that case, it is now, I believe, it's 5:58 PM, and we'll close the hearing. Thank you very much.
Thank you.